Well, I hope you were able to join us yesterday when I sat down with Andrea Burkhardt and we discussed many, many issues regarding the Karen Reed case. It was a conversation that lasted over 2 hours long. We also took some questions, and it was really refreshing and enjoyable to talk to such an intelligent and really brilliant legal mind. She has a channel. You should definitely go check out that channel and subscribe to her channel. It was a great conversation. I enjoyed it. And that video is actually still posted on my channel. If you haven't seen that, definitely go check out that video. A lot of very interesting topics that we covered, and hearing her take on a lot of these things was also very interesting. Now, before we move on to the topic of today's video, I want to revisit some of the topics that I spoke with Andrea about yesterday. And that was, number one, was this order regarding Crosby. And as you know, I found that very difficult. It was very challenging for me to understand that order, being that Dr. Marie Russell had to undergo a 2-day Daubert-Lanigan hearing, despite her extensive experience in the ER treating and diagnosing dog bite wounds, as well as her experience in forensic pathology. Now, you got this Dr. Crosby, who seems to just have a degree in veterinary science, not a veterinarian, not a doctor, and not a medical doctor, and not a forensic odontologist. And now he is going to be giving an opinion to the jury regarding causation, essentially, of these wounds to John O'Keefe's arms. So I found that very interesting, the fact that Judge Cannone is not even going to make him go through a Daubert-Lanigan hearing. So that was very troubling for me. That's one of the things I brought up with her, and she agreed with me. And the question really was how strong of an appealable issue it is. I thought it's a very strong appealable issue. She felt that is definitely an appealable issue, maybe not as strongly as I do about how strong it is, but we moved on to the Betterow issue, and that she felt was a very strong appealable issue. The fact that Judge Cannone is not allowing Mark Betterow to join the defense team, despite the affidavit that was filed, which detailed how Mark Betterow made sure that there's no sort of conflict of interest here, and any conflict is waived. Both parties had independent counsel to consult with. Nevertheless, Judge Cannone did not allow him to join the defense team. So she felt that that was a very strong appealable issue. We went through her order. Some of the order seems confusing to me, and also it's not very clear about why she's coming to her conclusions. I mean, she did say, well, because of the conflict of interest, which she believes is not waivable, but really no more details about that, why a specific conflict is not waivable. She just cites to some of the rules of professional conduct in Massachusetts. So that was another issue that we went through. We went through a whole bunch of different issues, and definitely go check out that video for the full extent of that conversation. Now, something that we did not cover yesterday in yesterday's conversation, because just the time did not permit, was the order that came down regarding the sanctions. Now, remember, the Commonwealth, Hank Brennan, moved for sanctions against the defense team. One of the things that he wanted was that there should be a gag order against the attorneys. Of course, he has no problem with Karen Reed talking to the press or talking to whoever she wants to, but he does not want the attorneys to make extrajudicial statements. And that was granted. So Judge Cannone did grant that part of the sanctions. However, from this order, it appears that all of the filings will still remain public. So they're not going to be impounded. Another thing that Hank Brennan wanted was that all of the filings should initially be sealed, be impounded, and then only after the Commonwealth gets to review it and the judge gives the okay, then those filings will go out to the public. So luckily, it seems that she did not grant that part of the motion, so we will still be able to get access to the filings in this case. So that's a big win for all of us. So let's move on now to the motion that Robert Alessi filed, and this was to strike the neurologist. The Commonwealth wants to call a neurologist to talk about certain things like cause and manner of death as it relates to John O'Keefe. So I'm going to pull it up. Hopefully StreamYard will let me show it to you. If not, then you'll just see a black screen, but hopefully you will be able to see what I am reading here. So this is part of the motion. As you know, I don't like to go through the entire motion, but just the main parts, which Robert Alessi is arguing that this Dr. Wolf, who's a neurosurgeon, should not be allowed to testify about certain things like cause and manner of death. So here we go. Although Dr. Wolf is a trained neurosurgeon, so he's actually a medical doctor, the Commonwealth has failed to prove that Dr. Wolf has a reliable basis in the knowledge and experience of his discipline, that's a quote based on a case, to render an opinion in the field of determining manner and cause of death, identify pattern injuries, diagnose post-mortem hypothermia, and properly read and interpret an autopsy report, all of which require the expertise of a board-certified forensic pathologist. Now, I want to just stop it right here, because since we are dealing with a medical doctor here, we're dealing with a neurosurgeon, so there should be at least a difference in the way that you approach the analysis here when you're talking about a medical doctor and his opinion about causation, as opposed to somebody like Dr. Crosby, who's not a medical doctor. So You have to take each thing by itself. So number one, manner and cause of death. That's going to be a question which we're going to get to soon. The next thing is identifying pattern injuries. So these injuries, let's say to John O'Keefe's arms, is a neurosurgeon able to testify about that? Is that something that's within his expertise to testify about? Generally speaking, a doctor is limited to his field, what his expertise is. Now, we know an ER physician like Dr. Russell, she deals or has dealt over the past 30 years as an ER physician with pattern injuries. That's part of what she has to do as an ER doctor, deal with these type of injuries. A neurosurgeon, not as much. A neurosurgeon usually deals with the brain, issues of the brain. So like MS, those type of things, that's where a neurosurgeon has expertise. Question is, when it comes to pattern recognition analysis or these abrasions on John O'Keefe's arms, is that really in the purview of a neurosurgeon? So that I think he has really a good argument. Continuing, hypothermia. Hypothermia is another question. I have seen some cases which allowed neurosurgeons or neurologists to talk about hypothermia and properly read and interpret autopsy reports. Okay. As a neurologist and clinician, Dr. Wolf's background, training, and experience is limited to treatment. He is not board-certified forensic pathologist. He is not a board-certified forensic pathologist and has no training or experience in determining mechanisms of injury or the cause and manner of death. Now, there's a reason why Robert Alessi is calling this a mechanism as opposed to causation. And he's trying to split hairs here. And causation, generally speaking, as we know, a doctor could testify about causation. Well, it's going to make any sort of difference when you're calling it a mechanism. And if you try to look the difference between a mechanism and causation, it's not really so clear. Mechanism is much more, let's say, detailed of exactly what it was, the trajectory of any specific injury which caused the death, as opposed to, let's say, more of a broad category of a causation where you can say, yeah, the car accident is what generally caused this condition, as opposed to, something much more specific that would go into mechanisms. And, he's trying to split the hairs here between mechanism and causation. That's what I'm seeing from this motion. And continuing on, he says like this. In his report, Dr. Wolf repeatedly exceeds the scope of his qualifications by reaching opinions on cause of injury. Namely, the mechanism of injury was a fall backwards. The head injury was clearly inconsistent with any type of mechanism of injury, such as a bar or hammer or a car hitting him directly. So, right away, this is taken from Dr. Wolf's report. And here he's very clearly talking about this trauma to a person's head and what caused those injuries to John O'Keefe's head, right? So he's saying that this is a fall backwards as opposed to a bar or hammer. Now that's something where you can make the argument that a neurosurgeon, even though he's very well versed in the brain and anything that has to do with the brain and brain injuries, but to specifically say that this is from a fall backwards as opposed to a bar or hammer, that's where the argument's going to be that this is not something within the purview of a surgeon, a neurosurgeon, to be able to say whether this is specifically from a fall backwards as opposed to a bar or hammer. The frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Stop right there. So it seems here that he's talking about how hard the ground is. This would definitely look like this is out of the expertise of a neurosurgeon. A neurosurgeon does not have expertise regarding how hard a ground could be when it freezes. That's not in the neurosurgeon's expertise. He can't testify about that. He could testify that if the ground was hard enough and somebody fell on the back of that ground, then maybe this is what caused that injury to the brain. That's possible. But to be able to say that the ground was frozen enough that it's so hard to then be able to cause this injury, that is where Robert Alessi definitely has a very strong point here. Again, the frozen ground is not for a meteorologist either. There's specific expertise which can tell you exactly how hard a ground is after it's frozen and the freeze and thaw cycles, whatever. That's not really in the area where in the expertise of a neurosurgeon to testify about. So that I think he's absolutely correct about. Ultimately, his death resulted as a combination of the brain injury and his hypothermia. Here, Dr. Wolf has no experience in diagnosing hypothermia from a dead body, no experience in identifying pattern injuries, and is not trained to read and interpret an autopsy report. In fact, by law, a neurologist is not qualified to issue a death certificate declaring the cause or manner of death of someone who dies of unnatural causes. He is not a forensic pathologist and lacks the appropriate licensing requirements and training necessary to do this properly. So he's just simply saying, look, he may be a great neurosurgeon, but when it comes to determining cause and manner of death, That is for forensic pathology. That's not for neurosurgeons to determine. Now, I do want to show you something, but I want to first get to the end of this and see if I highlighted anything. I think I did. Here we go. Moreover, in reaching his opinions and conclusions, he ignored the precise information that must be considered in determining cause and manner of death. Namely, he fails to address or acknowledge the abnormalities present in the decedent and fails to acknowledge any evaluation of the toxicology report, both of which are critical steps that would be considered by anyone trained in forensic pathology in determining cause and mechanism of injury. So remember, there's always two prongs when it comes to a challenge for an expert, the Daubert-Lanigan challenge, right? So if you want to challenge him, there's two parts. One of them is his qualifications. That was his first argument. And now he's getting into more of the methodology that this neurosurgeon, Dr. Wolf, now we're going to have two Dr. Wolfs in this case, by the way. So now Dr. Wolf, he's saying that he he failed to address or acknowledge anything that has to do with the toxicology report and some other thing we're going to see in a minute. He also, further, the section of the death certificate that is most often misunderstood is the other significant conditions section. Here, Dr. Wolf neglected to acknowledge the entirety of this section in his report. So that's what his attacks were on his methodology. So he didn't read the reports properly. He didn't take everything that you're supposed to take into consideration before determining cause and manner of death. And that is why even his methodology is not good. Now, I want to show you something from a case that I pulled up. And this is a case that actually, as you know, I like to do a little bit of research about whether or not neurologists can testify about cause and manner of death. Now, in this case, this is Commonwealth versus Medina. Just let me double check on that. This is Commonwealth versus Medina. There you go. And in this case, the defense actually called a neurologist. So here's the defense calling a neurologist. And this is what it says here. Dr. Donald Green, a neurologist testifying for the defense as an expert witness, opined that the cause of the victim's death was bronchial pneumonia and meningitis. But in response to a question by the judge, stated that he had no opinion as to whether these causes were secondary to blunt force trauma. So in this case, at least, again, the analysis of this case is not whether Dr. Green was qualified to be able to give this opinion, but you do see in this opinion that Dr. Green, who was a neurologist, was able to testify. The judge allowed him to testify about cause and manner of death. So you do definitely find in the Massachusetts case law that a neurologist can potentially testify about the cause and manner of death. So what eventually is going to happen in this case? Well, as we saw from Dr. Crosby, Judge Cannoni had no problem with him being able to testify without a Daubert-Lanigan hearing. And what it seems to be is that he was not qualified at all. And even if he was potentially qualified, she did not make him undergo a Daubert-Lanigan hearing. So do I think that the outcome of this is going to be any different? Of course not. I don't think that's going to happen at all. Even though perhaps it should be when you have a neurologist to know exactly what the scope of the expertise of a neurologist is as opposed to a forensic pathologist. Something else that is also noticeably missing from this motion that I did not see is an affidavit filed by some sort of forensic pathologist and something like the medical examiner that the defense does have. And they do have some medical examiners that testified in the last trial. And there's no affidavit attached by that medical examiner. Like we know with Dr. Marie Russell, when it came to Crosby, she did attach an affidavit saying why his methodology was not sound and why he's not qualified to be able to opine about the injuries to John O'Keefe's arm. Something that we do not see in Robert Alessi's motion here. So that's also something that's a little bit different, which is also going to give maybe another out for Judge Cannoni to just completely deny this motion outright. So should there be a Daubert-Lanigan hearing for him? Sure. I think there should be, specifically to know exactly what he's allowed to testify about. Definitely when it comes to the frozen ground, how should he know about how ground freezes and how hard ground can be? How can he know the difference between whether it's a hammer as opposed to a fall backwards? How can that be? So these type of issues I think should be fleshed out with a Daubert-Lanigan hearing. Now, is that going to happen? I don't know. At this point, as I've seen from Dr. Crosby, where she allowed that without any sort of Daubert-Lanigan hearing, it wouldn't surprise me if she also just denies this motion outright. But I do believe that at least a Daubert-Lanigan hearing should happen for this doctor. And again, I don't know why Robert Alessi did not attach an affidavit from some other forensic pathologist or some other neurosurgeon saying that this is beyond his expertise. I think that would have helped that motion a lot. So that's going to be it for now. That's what it has to do with this next motion that was filed. Again, we'll keep watching the docket. There was an order that came out today about the media, exactly what the media is allowed to do in the courtroom and what they have to do with the cameras when it comes to jury selection and otherwise, and sidebars and things like that. So there was some order about that, but nothing else that I've seen from the docket so far. So we'll keep watching it. Anything else that comes out from it, we'll definitely report to you and give you my analysis on. At this point, we're going to stop the video for today. So if you haven't yet, please subscribe, like, and we will see you next time.